Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. And today I have two guests with me from NYU School of Law. Richard A. Epstein, who is the inaugural Lawrence Tisch Professor of Law and also a director of the Classical Liberal Institute, an institute he helped found in 2013. And also Catherine Sharkey, who is the Siegel Family Professor of Regulatory Law and Policy at NYU School of Law. Welcome to you both.
Good to be here.
Thank you. Well, it's great to have you both here because I know that you have co-authored Casebook in Torts before, but today we're talking about a new first edition. You had recently worked on the 12th edition of Cases and Materials in Torts with Walters Kluwer, but today we're talking about Business, Defamation, and Privacy Torts. It's a first edition that is coming out, and so I'd love to start with finding out what prompted you all to write this Business, Defamation, and Privacy Torts book.
Yeah, so I should say first and foremost, Richard and I are true torts enthusiasts through and through, the gamut of all of the topics that are typically in the first year course, but also these more specialized topics that are in our business torts casebook. And probably for the last over a decade, maybe 15 years, in addition to teaching first year torts, where you really could just cover the first half of a traditional, robust casebook, like the one that Richard and I were collaborating on, I started teaching a separate class. It was either called business torts or advanced torts or privacy, defamation, and economic torts, all of those very rich subjects. And what I discovered is that the students were really interested in it. And also, as young alums, when they'd come back, they would tell me that these kinds of topics were first and foremost in the kinds of assignments they were being given straight out of law school. So Richard needed no convincing. He already, I think that both of us might have thought we should continue to teach all of these topics in a full year, first year course, but given that's not the way things go, we have a lot of enthusiasm for these subjects. We were eager to build on and then extend the traditional materials and really fashion it as a new upper level advanced torts or business torts course.
Let me give you some of the history of how this worked. I took over this book from the late Harry Calvin in 1977. And when I think I did the second edition, I realized that he did not have anything in the book that dealt with misrepresentation or economic torts. And so what I did is I added from scratch 2 new sections to the book so that you could have it for a year course. And the one thing when we move forward to this new situation, we had all this material in, but we have finished the 13th edition of the first half of the book, which essentially covers everything before this book. And this is the first edition of the second half of the book. And there's a little bit of overlap between the two of them because products liability is such a ubiquitous subject that many people want to teach it in the first year and others want to teach it in an upper division course. So we expanded it a bit for this edition for the specialists. And then what we also did is we beefed up much of the material in the earlier stuff so that it wasn't quite large enough for a course. Kathy had done a lot of supplementing on it. And so we added a new chapter on economic harms, both consensual and non-consensual, in which she turns out to be the most active writer in the country on the particular subject. We expanded the misrepresentation chapter. We added a little bit more in under stuff having to do with antitrust laws of one way or another. And we inevitably had to update for the internet and for all the modern controversies, all of the materials that were associated with privacy and defamation. So the book is probably, I would say, it's a third to 40% new, Kathy.
Yeah. Definitely. The one other thing I'll add, and then we can go to the next question, but I think Richard and I both found over the years of doing the last several of the editions that the material in the first half of the book, we would refresh it, get new examples, make sure that we were up to date on all the new restatement provisions, etc. But there was a lot more action, dramatic things happening in real life litigation and pressures along the tort contract doctrine, doctrinal lines, etc. All of this rich material happening in the second half of the book. So it was inevitably, I think we were adding to it when it became its own book.
Let me give you a kind of a very specific explanation. When I took this book over in 1977, Harry Calvin, who had done it before, had a great eye for cases. And if you look at the current books the cases that we have in the first section on intentional torts, I think we had virtually every one of them in the 1969 edition. as a primitive case. One of the principles that we both agree is if it's a new area, you take the best of the new cases. But if it's an old area and you have some chestnuts about which the law is organized, you don't take them out for a case that nobody heard about. What you're trying to do when you keep Vincent and Lake Erie and Vosburgh and Putney in the case book is there's a vast academic and secondary literature and judicial literature on these particular cases. And so what happens is you get a glimpse into something which is very modern in terms of the way in which people respond to it, even though if you look at the date on the cases, Vosburgh is from the 1890s and Vincent and Lake Erie is 1910 or whatever it is. So it's what we do is we fresh up the notes a little bit, but when you have two very different kinds of books, you change it. The one thing we did have to do, this is sad to me, when I first put the third edition out, I took the suggestion of my colleague Walter Blum. And he said, you have to add some material on the history of negligence and strict liability. And the original version of this had two separate chapters, one on the history, one on the analytics. I was trained in England, so I read all of these cases as a first-year law student many years ago. And what happened as we came forward with the following kind of people said, it's too long. And they don't cover enough stuff in procedure that let you do it. And so what we had to do is to take, in the first of these, take those two chapters, compress them into one. We did that some time ago. And then we had to reduce it by about 30 or 40%, adding in enough information so they would know what the ancient language was, dealing with rule absolute, rule discharged, and so forth, i.e. affirm to deny. And so that book, too, has changed in terms of the mix, although we kept the old cases because compression was in order, but there was very few new cases that came in which would alter the situation. So the two books get somewhat of a different treatment because the currency of the old cases in the modern areas is much lower than it is in the older ones.
So with two torts enthusiasts writing this book and addressing some new issues, but certainly new circumstances within which this law must evolve, how did you decide how to split it up between the two of you? And why don't you share some of the most significant changes that each of you are proud to have included in this first edition?
It's things, I have to say, working with Richard, things kind of happen organically, which is good. We both work fast and we sort of tell each other when we're going to have bursts of productivity and then hand things back over to the other. So I'd say we both worked on every chapter in this new book. However, it is true that we probably have larger imprints in certain of the chapters. And as Richard alluded to before, an important thing, there are always interesting and difficult decisions about how to frame casebook and how to lay out the material. And we made the decision to start the framing here with the so-called economic loss rule. And the more years that I was teaching this material, I did it in different order. I did it in various ways. So that was something that I think was an inspiration that came from me, which was I really think it helped to ground the students in both some theory and concept, but also some of the practicalities of why this material is so important and why it's distinct from what they might have encountered in first-year torts. First-year torts primarily deals with physical injuries, damage to property, and some emotional harm issues. So really this book, although it goes beyond this, but a through line on all of these topics is thinking about economic or financial harms, including in areas like defamation and privacy, where we're also thinking about reputational interests or privacy and trying to say, what are those interests? How would we characterize them? There is a component of them, at least, that is financial, and these arise increasingly in the real world in business tort litigation. So that was kind of an overarching theme to begin with.
Kathy did not know how precious she was. One of the cases she added in, which is extremely important, is a case called Sheen. And what this case does is to cut back on the freewheeling California jurisdictions in olden age. And it essentially says that when you want to create new causes of action, there is an implicit doctrine of state preemption of state case law. So if you have a complicated regulatory scheme, you're going to be reluctant to do it. And indeed, throughout this entire body, California case law is moving more conservatively rather than more liberally, whatever one might think of the state. Well, it turns out there's a real backlog. I've been working both in litigation and academic stuff on cases where you're dealing with physical harm, and the same argument can apply if the FDA is regulating the stuff. You don't want judges coming up and making these sort of random arguments. And so, in one sense, what's nice about all of this is that as you expand the stuff on economic harm, the students who are astute will start to see that it also deals with cutting edges in the litigation sense on material which is largely confined to the first issue. In terms of other areas that we added in, one of the things that I've worked on a long time has been essentially all the law relating to covenants not to compete. And this has become an extremely hot topic because there were moves by a variety of people. The governor, Hochul, actually vetoed a statute which said that all covenants not to compete are illegal. And that's never been the rule. It's always been a rule of reason. And so what we did is we added a section that talked about that conflict, ending, as it had to, with the last decisions that were made in the Biden administration, all of which were basically put on hold by the courts. And the casebook has a form of instant obsolescence and prescience at the same time, because what happens is the Trump administration will not continue with most of those policies that were very aggressive. And so when we talked about the disclosure rules, one of the important areas was disclosure of climate change information that should be done through the SEC. I wrote a long article on that, and I think that's probably dead today as well. But it's important that students know what these particular hearts are, because anyone who looks at the current political system will realize that there's certain differences of opinion between the Biden and Trump administration, and what comes may easily go. And so these things to some extent should come back again. So you have to worry about those sorts of questions as well. And then there was the financial fraud stuff. One of the cases that we made a principal case in the book was a judgment by Mr. Engoron, or Judge Engoron, which essentially agreed with Letitia James that he owed $385 million to the state for financial fraud on a bank which did not complain about it. So we put all of that stuff in the book, and not too much judgmental. But the last thing that happened, it is now under consideration by the Court of Appeals, and we just left it open as to whether it's going to stand or not stand. And so what we did is we had to finish this book when everything was hanging between the two administrations. We'd write it very differently if we had another year, I'm sure. But what we try to do is to position the book so that you are well equipped to understand many of the innovations, whether they be good or bad, of the Trump administration, based upon what we had written about these developments up to the very last days of the Biden administration.
And I want to just say two other, because I think they're a big part too of new material and really exciting material in this book. So the first is products liability. Well, it's true that we do have a section on product, we do have a chapter on products liability in the first year because we both teach it in the first year course. We've added really products liability in the digital age and a lot of really interesting activity in the course. I was giving some lectures to judges recently, and then I was on a symposium yesterday with all of these ideas about social media platforms. Now the newest thing is character AI and chatbots and generative AI. And are these things products or not? And it turns out, this dovetails with Richard and my approach, I think, to teaching torts is to answer those kinds of questions. You have to go back to the fundamentals, to the historical evolution of why we have products liability and trace those early cases all the way forward to ask about the underlying policy reasons to answer the question, when should information be treated as a product or not? And then a second area is public nuisance. So this is an area, Richard and I don't shy away from controversial areas, and we might have our own either policy or ideological views about how broad or narrow the tort doctrine should be, but we are really in agreement about how to lay out the fundamental cases to teach students the evolution. Sometimes you hear in these modern debates that public nuisance is just a newfangled tort. It's just for anything under the sun, all of our social ills. Well, it's a very historical tort going way back into the 14th, 15th century and 1535, 16th century, right. In the anonymous case, a private actor who comes forward and sues in public nuisance. But we bring that all the way up to examine public nuisance in the opioids or in climate change or lead paint, but to understand these contemporary debates and weigh in, our belief is you really need to be grounded in the historical evolution, and then you can argue on something that's not just policy preference or ideology. It's really about the principles of the tort doctrine.
And by the way, this is not a small problem. There were the recent bankruptcies that took place with Purdue. And what happened is there's this very novel theory that even if they didn't make the product, somehow or other they could be held responsible for fentanyl that came from other sources. And we were able to hint at that and try to get something going. But what really happens now is there's a case from Hawaii, which is before the Supreme Court. It sat there for 9 months? Because what the Biden administration did is it says, we want to hear from the Justice Department. The Justice Department did not want that case to be heard under Biden. So it basically never said anything until the last days of the administration. And chances are this will be completely undone. Right now, we can't deal with this, and it's not necessarily a tort case, but there are many people in the Trump administration who tried to change the endangerment finding, which was associated with the Massachusetts case. And we have some sense about whether you want to treat carbon dioxide as a pollutant, because we put some of the earlier cases in on this topic that are hanging fire at this point. And then we integrated it with the preemption issues that were raised necessarily on their back. So anybody who teaches this is going to have to supplement it. And if you have to supplement a case book coming out in December of 2024, any book is even earlier is going to be hopelessly out of date. And, we could at some point perhaps put out a short primer as to the things that we would want to add in, depending on how things start to go. But essentially what we did is we made this book as current as is humanly possible, literally making changes in the book in gout, only literally a week or so before publication. As Kathy said, we both write fast. And in addition, we had a remarkable team of students who helped us, not only on the fly specking, but also with some sense on making sure the accuracy was there. And I think it's important that readers of the book know that this is not something that we just dreamed up and put out in a hurry. We had a lot of checking on this by people, our research assistants, who turn out to be extremely knowledgeable.
Yeah. And more than that, too. I mean, I taught basically out of previews of this book for about 15 years, and then right up into the date we got on our team. We had a pretty extensive team, but we had some great students who had taken the business torts course and understood the framing, et cetera. So I would say, it's been, as case books go, it's very current and it's very accurate, and it's been vetted by us, but also by a lot of students. And we dedicate this to our students because they really did inspire us, and then also really helped us get it to the finish line as well.
By the way, the students were not only from NYU, but I still have a part-time appointment in Chicago. And we had my Chicago team of super research assistants work on this as well. So we probably had, in total, the number of people is probably about 12 or 14. Is that about right?
That is quite a team. That's fantastic.
I mean, because we understood the nature of the changes, and it's very easy to make mistakes. And so what we do is the students first collected the information, what they thought was relevant. Then we would write it into our blurb, and then we send it back to them to check. Because the compression issue raises a real question if you're leaving out facts that really matter or doctrine that matters. And the students, they go back and they make sure that you didn't slant the thing in one way or another. Essentially, what we try to do is to put a book out there that people of any ideology or preferences could teach from, because it's a reliable base rather than essentially an argumentative treatise.
Well, I love hearing you discuss this book because it is all the sexy, updated, current topics that we read in the news. And I wondered, since you've grounded it so well in the historical setting, when we look at things like the opioid epidemic and having public nuisance apply to that, or product liability in the modern digital era, when you're thinking about things like algorithms or AI or with deep fakes and things like that, do you find, as torts experts and enthusiasts, that these are topics that lend themselves well to the common law development and those historical ideas and application work in the modern era? Or do you find that there is a need for some significant policy discussion and perhaps regulatory and statutory changes related to these new technologies and circumstances?
Yeah, so I would say both. So I was about to go full into the common law until at the end of your question you added regulatory and statutory. So maybe we should have said at the outset to this book, both our first year case book and this book very much is common law in the age of statutes and regulations throughout. So when we're talking about products liability, before we get to the digital age, we are talking talking about the interplay between federal regulation of medical devices and drugs and the common law and the interplay. I don't think in that some schools have gone to changing the name of torts to tort and regulation. I don't think one needs to do that, but and in some sense, what those kinds of courses sometimes do is leave out the whole common law evolution. We include that, but we are very conscious of the interplay with statutes and regulations. So if we expand the question to that, then I would say we both find that the study up until and the application to these modern issues a lot to offer from this common law with statutes and regulatory approach. When you say, or do you need to have kind of policy and maybe ideological discussion? If you take our teacher's manual, you will then see in various of these areas, including on opioids, on climate change, you will see, because Richard and I have some pretty vehement policy-based disagreements about where those come in. That's where you see that play out. But I think what's remarkable about this book, and it's unfortunately all too remarkable, I think, in our modern 21st century, is that we can have that, and you can see that erupt in the teacher's manual, but we agree full stop in the laying out of the fundamentals, and we don't cheat. A lot of times people have very strong policy views about how something will go, and they'll make these comments like public nuisance didn't exist as a historical matter. You can't cheat when you use our book, but you can have very different kind of policy-based conclusions on the basis of these core materials.
By the way, about with the teacher's manual, again, with a lot of student support, we considerably expanded it to take into account these developments. If we agree, we kind of announced that we agreed, and where we disagreed, we announced where we disagreed and why. But it turns out that we hope that the teacher's manual will be a significant teaching aid because it's just not a series of random jots and so forth. Basically, it's every case and every note on every case gets some kind of analysis. Now, with respect to the integration of statutes and common law, I am trained as a Roman lawyer. I am trained as a medieval lawyer. And the interaction between common law decisions and statutory decisions basically goes back to the beginning of time. And one of my nice little ways just to get the point across historically is when the United States decided to break off from England in 1777 and so forth, the first statute on the books was the common law of England as it exists on whatever it was, 1777, is the common law of New York. And the great question arose, is the statute of frauds a common law rule? And you could say it's not, but then all the cases on it become utterly incoherent. And so what happened is, even from the earliest times, those statutes which so integrated themselves into the common law framework were treated as part of the common law and understood to be such. And so when you're trying to talk about private rights of action that take place when there's an injury and breach of a public statute, the first case by Lord Holt, who's one of the great English geniuses from the early part of the 18th century, he makes it very clear that you have private rights of action that come out of these if you're subject to special injury. And then what happens is the exact same issue comes up later on in the American cases in the 1970s and so forth. And what they do is they kind of adopt the same sort of rule. Special injuries give you kinds of special rights. General injuries do not. Then when you move forward to the stuff having to deal with public nuisance, it's exactly the same thing. The general special distinction is raised in 1536, and the interaction between a statute and a common law rule was raised in the same case. So the rule said if this was a generalized harm, the traffic that was slowed down, there was an action in the court leet, an administrative body, to put a fine and to remove it. But if you were somebody who's special injury, that is, your driver was blocked or your car was hurt, you would have a private right of action. Now, the question is, does it last? Well, if you start looking at the modern cases, they have exactly the same distinction. And what happens is all the pressure then comes on the word what's special and what's a general damages. And we have a bunch of cases which ask that question. Everything that hurts the world is a general damage. It's one specific guy. But suppose you shut down 3 blocks of a New York street because you're having to do renovations on it. Is that special because you have only a tiny part of the city, or is it general because you have 100 houses that are there? We put all of that in the book and so forth, because every time you draw a hard line between two sides, general and special, or specific and general, it turns out the world is not as neatly categorized as the distinction is. You can't get rid of the distinctions because you have to worry about the ends. And so you have to then spend your time finding out where it is. Now, where is this coming up today? If people are curious, the statute that authorizes Musk run his various kinds of investigation allows him to create by executive committee only projects with specific orders. Same language that you get in the cases. So what we try to do in this case, if you understand a lot of these conflicts, they don't just stay in tort law. They become templates for what you're going to do when you deal with very modern regulatory issues. It is commonly misunderstood as to how important all of these early things are when you're trying to do it. So many of the modern debates are now debates over what would happen in the 19th century or the 18th century, birthright citizenship being one of them. And it turns out you really have to understand the interaction between common laws and statutes. So we're giving them a template of that, and hopefully, if they understand the dynamics, they could apply it to areas that are not regarded as tort.
Well, I have to say, the topics that you've covered in this book are fascinating and honestly ripped from the headlines. So it is very relevant to, I can see why you say, to alumni who are practicing in this area, as well as students who will prepare for the practice of law. Congratulations again on Business Defamation and Privacy Torts, first edition. This is really an exciting book that carves out material that is very current day and can be used in an advanced upper division course or a seminar on torts. So before we get to well, we are at the final question, actually. I didn't warn you in advance, but I think both of you can come up with an answer on the fly. I'd like to ask each of you what you think the future of legal education will look like in the coming decade. How is it likely to evolve?
Well, I'll tell you that, Ken. We don't know. I mean, one of the things that I was asked, I'm on the board of your company, Aspen, right? And I was asked that question yesterday by an email. And this is what I answered. I said, if you're looking at the private law curriculum, for the most part, as best we can tell, they're going to be relatively incremental changes with the frame of the statutes. But if you're dealing with a public law area, constitutional law, administrative law, a federal jurisdiction, and so forth, environmental law done by statute, you're going to have to rewrite the books. And so, for example, my friend Erwin Chemerinsky, who sits on the board with me, he said, this year I am teaching constitutional law by starting with executive orders. Well, why is he doing that? Because the fusillades of executive orders that have come down in the last month have been the most profound set of changes, for positive and negative, take your pick, that have ever happened in the history of American law. Even Biden, who did a lot of this stuff, I would guess it was, 10 or 20% of what Trump is trying to do. Kathy, so you do agree?
I would say, sort of writ large, that legal education is going to have to address artificial intelligence. And I think I say that because a lot of my own work has gravitated towards wrestling with topics. So I did some work in administrative law looking at how federal agencies are using artificial intelligence and then thinking about how we should be regulating that. I became interested in it actually because I'm interested in medical devices and drugs, and the FDA was approving AI-enabled medical devices. And in dealing with students over the years, I realized that we are now attracting into law school more students who do have pretty sophisticated technical backgrounds. And our idea isn't, we're not training students who are going to build AI, but we need to train students who understand that law and legal concepts are going to shape the evolution of these technologies. I think too many technologists think they do what they do, and then the law will come in and say thumbs up, thumbs down. And so as a law school, sometimes I think we're maybe not moving quite fast enough. And there's a lot of attention on, would students use AI and ChatGPT, et cetera, to cheat, and less about how should we be how should we be kind of training them to be able to think about where the legal issues come into play in these emergent technologies. So that's
And
what I think
both of the topics that Kathy mentioned came up at lunch today. The cheating question and the technique question. And I'm going to go off now to a workshop, which is going to have to deal with this in the criminal law. My son is a writer, and one of the issues is, do they not need him because they have ChatGPT? But one of the reasons why ChatGPT, whatever it is, can work is they take scripts by published authors and use them to get the stuff. And the question, is that a patent violation on the part of the company? We could talk about. My inclination is to say yes, but it's certainly not going to be resolved clearly. So yes, the world will be excited, and we're going to have to all deal with it. And I think, in effect, all we can do is put one brick in a wall that we hope will make the students better able to deal with problems, which, in the case of every textbook, arise after its publication.
Well, thank you so much, Professor Richard Epstein and Professor Catherine Sharkey. And again, congratulations on your book, Business Defamation and Privacy Torts, first edition. And it was a pleasure talking with you this afternoon.
Thank you. Thank you for taking the time.
Thank you.